Good morning. How are you? Well, two events of the last week were very striking to me as someone who thinks about the rule of law and what it means. One, the smaller but still significant event. Now, as you know, way back in May, during some of the early protests against the murder of George Floyd, there were peaceful protests in Minnesota. Peaceful. Nobody was doing anything criminal or committing any violence. And MSNBC, of course, one of our major cable news networks, was covering these protests. And one of their anchors, Ali Velshi, was covering these protests. And the police shot him in the knee with a rubber bullet. A journalist doing his constitutionally protected job. Just last week, months later, that man Trump referred to this as a beautiful thing, the shooting of a journalist with a rubber bullet in the knee, and said that this represented law and order. This, of course, once again establishes that once you add the words and order to the word law, the law part disappears. All we're talking about is order and dominance. That's one event. Here's a second, and a much more significant, a very tragic event. Justice Ruth Bader Ginsburg passed. And besides the great loss that we all suffered because this example of great jurisprudence passed away, we all have to fear that a replacement for her shall be shoved through in the next couple weeks before the election. And many of us fear that not simply because, she was on, quote, our side, and Trump's appointee will be on, quote, their side. But many of us fear the collapse of the rule of law. 4 of the 5 justices on the Supreme Court have no principles whatsoever. And they are, of course, recent conservative appointees, but they're also conservatives without principles. And Chief Justice Roberts has a very, shall I say, sporadic commitment to principles. And by principles, I mean the kind of principles we will be talking about when we discuss the rule of law. So, but why do I say that? Is it just, as some of you might have said, well, that's Prince. He's so far to the left, he makes Bernie Sanders look like a Republican. Ha-ha. Yeah, it's true, but ha-ha. If so, then do I mean rule of law is just doing things the way I think they should be done? That would mean, for me, the phrase is simply just another form of manipulative rhetoric. Some of you think that's got to be the case, because given my often expressed disdain for the concept of rules, surely that's all I mean. It's all just politics, right? So here, today, we're going to try to get a grip on what someone like me means when I speak of the rule of law. Someone who doesn't say the rule of law means laws full of rules. Leaving out the word of in the phrase rule of law, that phrase consists of 2 short but very complex words, rule and law. It is the shorter of those 2 words, law, that is the most complex and the one we must understand most clearly before we can begin to understand this very hot topic, the rule of law. We cannot even begin to talk about the rule of law until we are settled on what we mean by the word law. So what is law? Jeremy Bentham famously gave a definition that by and large is still followed by what is probably the dominant school of thought in English-speaking jurisprudence, which is legal positivism. But it's one that I think we have to reject. Bentham's definition and then why we reject it. To paraphrase, and I take this paraphrase from the great liberal John Rawls, who was besides being quite an original thinker in his own right, he was a great expounder, a teacher, explainer of other people's views. Pardon me, need a sip of coffee. Excuse me. This is John Rawls' take on Jeremy Bentham. Law is a rule created by or announced by someone with legitimate authority to regulate the conduct of those subject to the law. Now, Bentham did not invent this definition. Many other people, for instance, John Locke, had a similar definition in mind. In fact, I think that John Rawls, when he was talking about what Bentham said, was just quoting what he thought was the universally accepted definition of the rule of what law means. It seems to be some kind of very common sense view of what law is. So, following the common nomenclature, I will call this the positivist definition of law. So, why do we have to reject that definition? Which I say we do. It is not one that can yield a meaningful concept of the rule of law. Wait, you're saying. That sounds circular. You're saying I can't define the rule of law without knowing what law is. And I can't know what law is without referring to the concept of the rule of law, a circle. Well, let me explain why it's not. I agree that we do not yet know what the rule of law means in full. And we can't know that until we further elaborate what law is. But we do know at least a bit about what the rule of law is normally considered. Rule of law is always contrasted with the rule of men or man or people, a singular set of people. That is probably the one thing everyone who talks about the rule of law seems to hold dear and central to their concept. But Bentham's definition cannot yield a meaningful distinction between the rule of law and the rule of some discrete set of persons, the rule of man, to use the traditional, very sexist language. In summary, whatever the law is, it cannot simply be having rules, because every ruler makes rules, but we reject many of them as ignoring the rule of law. Whatever the rule of law means, we would all agree that something of value is captured in that statement. The rule of law is opposed to the rule of people, persons. If the rule of law meant simply following the rules laid down, to quote a famous positivist, if the rule of law meant the rule of rules, that is in no way different than the rule of a person, an individual. After all, it's people who make rules. The positive response. You're missing the point. What we mean is that once the rules are laid down by that person, the rules are applied evenly, impartially, and are not arbitrarily changed. But how do we know what counts as impartial? How do we know what counts as arbitrary? Impartial means that like cases are treated in like fashion. How do we know what counts as like? Is there a rule for that? Is there a rule for how to read rules? And who gets to make those rules anyway? What is the rule for that? Who decides what it means? Simply adding more rules about the rules cannot explain what distinguishes the rule of law from the rule of people. What then can? It is how we explain the rules. It is what counts as a good justification for one's reading of the rules. And it is how well one ties that reading of the rules in one story to the reading of the rules in many other stories. It is, in effect, how well we craft a unified narrative and draw a reasoned moral from that story. Law is telling stories. This is what gives us the generality and predictability that makes the law something more than an arbitrary assertion of power, and that makes it possible to tell the difference between the rule of law and, to use the traditional sexist phrase, the rule of man. To circle back to the point I began with a few minutes ago, to understand the nature of the legal system is to understand the meaning of the rule of law. The two concepts are inseparable. If, as I argue, a legal system requires a shared process of constructing and justifying a coherent narrative for that system, then the rule of law can only exist in a public process of telling and explaining stories. There's a very misleading image that has a great deal of resonance in American discussions of law, and I bet we're going to hear more about it very soon. In particular, this image pops up when we discuss the act of judging, which is that judging simply requires a faithful application of self-explanatory rules to the facts that as fairly determined to exist. The analogy in American terms is often just calling balls and strikes the way an umpire in a baseball game should do. That analogy of just calling balls and strikes has been a real favorite in Senate judicial confirmation hearings, especially for the more conservative nominees, as hypocritical as that appears to be to most of us. The analogy is totally inapt. And we're likely to hear it again in the next few weeks, but it's totally meaningless. Law is not simply applying previously established, well-defined rules in at all the same sense as applying the strike zone rule in baseball. Law requires interpretation in a way that baseball does not. Typically, the conservatives' criticism of the previous sentence assertion about the way law is actually done is that there may be a lot of interpretation in the law, but there shouldn't be. The implicit assumption is that interpretation is activism. Again, that seems very hypocritical given recent Supreme Court decisions, but they say interpretation is activism, which involves changing the law from what it already was, and that and if there are any gaps in the law as it already was, it should be filled legislatively. That assumption is not only false, but incoherent. There is simply no such thing as a rule of law that is a rule in law, that is self-explanatory. The rule of law cannot be simply applying the rules laid down in the past without an interpretive act. The law is a system. This is part of its value. It may not be quite the seamless web of the famous cliche, but it is a web, or it is a law. An unconnected list of rules is not law. Law aspires to coherence. Moreover, some of these strands in this webs are more fundamental than others. Though there's a very slippery distinction between rule and principle, and it raises all kinds of heated controversy that I don't think really needs to be resolved. It is reasonable to say that some of the strands of legal doctrine are more like principles, in the sense of not only being more general, but also more necessary as foundations for the more specific, quote, rules. Any attempt to find rules that are clear enough to be self-interpreted, and then to find an authority trusted enough to know and follow those self-interpreting rules, devolves into a form of social control that consists simply of the law being what the authority proclaims it to be, irrespective of any form of justificatory reasoning. But simply having a way to identify the proper authority to speak commands, and then assuming the commands are generally followed, is far from enough to identify what counts as law, rather than some other system of social control. Now, I've been talking for quite a while, and nothing I've said is an argument. I've just been making assertions. Now I'm going to start my argument. But as my argument is that law is a form of telling stories, I'm going to begin with a story, a parable. Imagine a simple village. One might imagine the sort of village life that was prevalent in Neolithic times, right at the beginning, say, of sedentary agricultural life. Further imagine that this village recognizes an authority figure, say, a wise woman, someone whose decisions the village will follow. When two people in that village have a dispute significant enough for it to require social intervention, the dispute goes to the wise woman. What she decides about how to resolve the dispute is recognized by everyone in the village as binding and authoritative. The village will, of course, have traditional customs which everyone takes seriously, but like any rule, these customs will require application and interpretation for particular situations. Disputes about the scope and meaning of these customs will arise. For example, a dispute may arise about the geographic scope of the fishing rights of two families. If the dispute cannot be resolved amicably between the two families themselves, they go to the wise woman. Now, if the wise woman is truly wise, relying on her judgments may work out to be an excellent way to resolve disputes, a perfectly acceptable method of social control. It may work very well, at least as long as she's alive and active, but it's not law. If the only reason we have for doing something is because the wise woman said so, we don't have the law, we only have the wise woman's accepted authority. What then does it take to move this form of social control down the path toward law. It would be a big first step if the next day, when the two other people have a similar fishing rights dispute, they settle it between themselves in a particular way that they judge to be similar to the resolution the wise woman used the previous day, because they feel they can reasonably predict what the wise woman would do. But what sort of dispute would count as appropriately similar to the first one? What guidance do the two new disputants have in calculating what a similar settlement would be, assuming that the second dispute is not simply a mirror image of the first? We can return to that question in a moment. But first, let's look at another step down the path to law. The wise woman is now gone. Maybe she's dead, or maybe she's simply become incapacitated for some reason. And someone else must take her place. The new wise woman, faced with a dispute similar to the earlier one that the first wise woman resolved, chooses to resolve it in a way that she finds similar to the way the former wise woman resolved it, and does so explicitly because the new wise woman is attempting to follow the first wise woman's example. But again, we have to ask, what sort of dispute would count as appropriately similar to the first one? And what guidance do the two new disputants, in the case before the new wise woman, have in calculating what a similar settlement of the dispute would be based on what they know about the earlier dispute? The next step then, remember we've already, the predictability issue, the continuation and stare decisis, points we've just made, they're not enough. The next step is the one that the wise woman could take herself, which begins to answer the questions we just raised about what counts as similar disputes and similar rulings. That step occurs when the wise woman not only gives a ruling but explains them. She gives her reasons. The reasons tell us what is relevant in the dispute to her decision and what her decision means, in a very real sense of the word meaning. But that step forces her to take yet another step. The wise woman's reasons must fit with the reasons in other cases. By must, I don't mean that this is a logical necessity or that it's absolutely inevitable, but it is conceivable, and in fact it is conceivable, that every decision is viewed as one-off and unrelated to any other, but at that point there's no reason for given reasons. Once it occurs to the wise woman to give reasons for her decision, it is practically necessary for her to try to harmonize her reasons in every case that comes up. So the case one fits with case two. When the wise woman's decisions begin to be understood as justified by a connected set of reasons, the village is building towards a legal system, one with predictable rules. That is, where we can predict where and when a rule will apply and what it will require. More than that, the reason for those rules will not simply be that the wise woman said, hey, they're the rules. Her connected justifications for her rules take on a life of their own. Her explanations begin to matter. The reason the village will follow the rules is that they will see them as the law, rather than simply as the commands or recommendations or advice of the wise woman. The decisions taken together form a coherent whole, a consistent narrative, relatively consistent. Now, let's pay attention to what is not the point of this story, this parable I just told. It is not the point of the tale to say that the rules that are considered rules solely because some authority figure states them to be the rules. And it's not to say that should rules simply be rules because the wise woman said them. They'd be bad rules. They might be very good rules. And it's also not the point to say that rules that are tied together through some kind of coherent, consistent narrative necessarily are going to be better than a one-off decision by the wise woman. Maybe her one-off decisions are better than the system of law that's developed by a less wise woman. But the point isn't which one's better. The point is one of them is law and the other isn't. No matter how good the wise woman's rulings are, without the justification, without the stories that tie them together being tied together as a coherent narrative, it's not law. After all, what would the rule of law as opposed to rule of the wise woman look like in the early stages of the story before she started giving her reasons? When the only reason her rulings are followed is that she's the wise woman, and the only explanation for the rules required is that they're her rulings, then the rule of law and the rule of the wise woman are the same thing. But on the other hand, the wise woman can see the wisdom of coherence, of justification, and thus of the law. And she can make it her life's work to be the first wise woman in the village's history to begin to give explanations, and in turn to try to make her explanations consistent across the history of the rulings she gives. If she rules differently in what appears to be a similar case, she feels compelled to explain why the cases are different and how that difference leads to a different result. Furthermore, if she comes to the conclusion that one of her earlier rulings was wrong, she will explain her change of view, and that explanation almost surely will include an attempt to show how the new resolution of the problem fits more consistently with all her other still valid and accepted rulings. What is beginning is not only a legal system, but the possibility of the rule of law. But like I've alluded to before, even wise women are mortal, and when she dies, another will take her place. The new wise woman may honor her predecessor's achievement rhetorically, and use fine-sounding language to suggest that she's doing the same thing as her great predecessor, but effectively ignore her predecessor's work. When asked why she rules the way she does, in effect, she can answer, because I think it is the right result, and you decided to give me the power to make that decision. She may have the authority to rule, but the legal system of the village is going to die in its infancy. But why are the new wise woman's pronouncements insufficient to be part of the legal system? It's just changing, that's all. The answer is tied up again with the notion of rule of law. If a system of social control is a legal system, there must be a way to have that law, the system, rule as opposed to the person who announces it. Rule of law requires, according to many generally accepted views, generality, publicity, prospectivity. General, public, prospective, and predictable. The last is most important, I think, predictability. For law to have any of those characteristics, it requires accountability. We cannot predict what the law will be in the future unless we have a reasoned account of why it meant what it did in the past. And the person giving that account is held to account for it. The reasoned accounts we use in law are necessarily narrative because the purpose of law is to guide behavior, to shape the stories of human events. No structure of rules, no matter how well they fit together, is of any value until those rules are matched with the stories to which they apply, to evaluate and prescribe consequences. Now, so far, it may appear that the point of this lecture, and those of you who are actually enrolled in this class instead of auditing, will have a much longer and hopefully not too tedious version of what I've said here, including a whole section elaborating what I just said here in much greater length. But anyway, this lecture so far may appear to simply be about saying that the law is not simply following the rules laid down by authority. Okay, that's what law is, because that concept is insufficient to explain the distinction between rule of law and the rule of people. That's part of the point. Sure. But another point that follows is equally important. And that's the part I'm going to dwell on a little bit. Not only is simply following the rules insufficient to make a legal system, but following rules is actually an incoherent ideal. Even the notion of who counts as the authority to make the rules and which of that authority's statements count as rules requires interpretation. The rules deciding who is the boss and when their statements are binding, what legal positivists like to call the rules of recognition, must themselves be explained and applied. Further, getting past that point, every single rule requires some interpretation, and many require a great deal. So even the rule of recognition requires a great deal of interpretation to decide who is indeed the authority. Either these interpretations are totally freestyle, or they are bounded by further rules or principles that help determine valid interpretation. But those very rules of interpretation require more interpretation. To quote a famous aphorism, it's turtles all the way down. So how do we solve this seemingly eternal indeterminacy? And I will confess that early in my own career, when I was affiliated with critical legal studies, I and my colleagues tended to say, it's all politics, period. So, do what you can. It's all a fraud. We tended to say that. Nobody still says that. It's interesting. We've all evolved away from that. And I, in particular, find that attitude is not just cynical, but, as we've learned in recent decades, a gift to people we don't approve of. If it's all politics and there is no principle, then how can you criticize what is going on these days with the Supreme Court? We can't solve this indeterminacy, though, really. We can see it in a different light. There are no fixed bedrock authoritative answers. There's only the ongoing process of telling a story that demands narrative coherence. Ultimately, there are no right answers to the more vexing legal questions, but there are acceptable methods of arriving at good answers, and those that are acceptable depend on storytelling skill, not brute claims of power. And a good story demands a moral. You got to tie it together. So again, law is a story, and the rule of law is being true to that story as we continue to write it. And being true to a story is knowing the moral of the tale. Now to bring it back to where we started, with the tragic news that we have a loss of a great justice, the late Ruth Bader Ginsburg, and we have a big hole that is likely to be filled, will be filled, and quite possibly will be filled in very short order before the election, in order to shove through yet another justice who agrees with people I don't agree with, okay? And we're not supposed to say, hey, it's all about who we agree with, right? It's not supposed to be nothing but brute politics, right? Pure ideology. There's supposed to be something else going on. Can I identify why I'm disturbed at the notion of someone on the, quote, other side being shoved through? Because not simply that these justices on the, quote, other side have proven themselves to be quite conservative, and we all know I'm not. That's not the point. That is a point, but that's not a point for this class, and that's not a point as a lawyer or a student of law. That might be a point out there in the world of street politics, but in the world of law, the point is not simply I disagree with them, they're too far to the right. The point is and I'm on record for saying this, and I'll say it again, they have shown themselves to have no respect for the story. Everything changes. There's nothing. This is why I referred earlier to hypocrisy. Instead of calling balls and strikes, one day it's baseball, the next day it's soccer with these people. They just pick out any game out of the hat and claim that that's what's being played. There's literally no way you can tell a coherent narrative that includes the decision that eviscerated the Voting Rights Act, that extended the Second Amendment to an area it had nothing to do with in any of the text or history of that amendment. The Citizens United, it's very hard to tell a coherent narrative that includes the most significant decisions of the 5 Supreme Court justices who can be identified as Republican in their leanings. I don't always agree with the 4 others. If I were on the court, I'd decide differently than a lot of them, in probably every case. And maybe I'd be right. Maybe I'd be wrong. Maybe you decide very differently from me. But we would have to all engage in the process of telling this story in good faith. And I think I'm going to end today with those 3 words and look at them again. In good faith. I think you can tell when you read a story whether the author is telling the story in good faith. or whether they're just being manipulative. I think you could tell whether it holds together in a way that seems plausible, coherent, and whether they're trying to tell a story that's plausible and coherent. To me, good faith in judging is attempting, sincerely and genuinely, attempting to craft a coherent narrative rather than simply doing what you want. That is the difference between a legislator and a judge. A judge has to craft a coherent narrative, and to be blunt, I don't think the current conservative majority has any interest in doing that at all. And that's where my concerns lie. Well, I'm going to quit there. I appreciate you sitting through this 42 minutes or so. Remember, those of you who are actually enrolled in this class, there's a reading that goes along with this lecture that's a whole lot longer, and hopefully not too tedious. All right. Thank you very much, and take good care. Appreciate it. Bye-bye.